Welcome to Looking at Legal Stuff. Today we have 8 hearings in the case of a mother in recovery who has had to allow her identical twin sister have legal guardianship of her son for the last 6 years. She's been given a 4-step plan that she has to work through before she can have her child back, and things start out really well. So well that the guardian offers her extra time. But things turn rocky when Mom gets a new jailbird boyfriend and she starts refusing to tell her sister where she's taking the child overnight. Mom claims she's ready for the final phase of the visitation plan, but the guardian claims that Mom is currently being evicted from her home and is now camping in her boyfriend's family's yard, and she doesn't feel that's a stable place for the child to spend the night. Let's see what the judge thinks.
Let's go to guardianship of Gabe, and Ms. Gill is here. So we've had joint visits for about a month, and Ms. Gill, why don't you go first? How have those been going?
I think the visits have been going pretty well. What I decided to do the last 2 weekends was kind of transition him a little bit, where 2 weeks ago we spent like the last half hour or so at her house so we could see the inside of it. And then this last visit, we tried to kind of split it up in half. It wasn't exactly half, but we spent about 1 hour and 45 minutes at her house. Because I do know the change in environment there is going to make him a little anxious. So I thought maybe if we did it together, it could help him out some. And he seemed to like that. I think we did a couple things. We went out in public. We did some mini golf, which was really fun. Went to McDonald's. She got to kind of experience why we don't go to restaurants as often, but it was nice. It was nice working as a team. Like my sister said, it's been really hard for us to work as a team just because of the differences, or, the circumstances aren't where they should be for Gage. So it's just very promising seeing her in a place where we can connect for him. And I feel like she's finally seeing it as like we're both his parents, and that's something we can't really change for him besides working together for him as a family. And it's just been a lot nicer that way, I felt. And then I know she did tell me she's gotten her license back, and a blow tube. She drove to our house this last weekend. I don't know like the insurance wise or whose car it is, but I know she will have to get like a car seat so that she can transport him. So it seems like everything's kind of working its way out right now.
All right. Ms. Johnston?
I agree. This is probably the first time in this whole case that me and my sister have been able to actually work together as a team. And it's been really just promising. Like, I feel like Gage feels more secure in it, seeing us both work together. And instead of like, when it comes to like just doing little things with him, like with making lunch, we've worked together on it, and I've, asked her what her ideas are, and maybe we could do it together. So Gage sees us as a team, and it seems to be working really well. I don't have anything bad to say. I did get my license. I do have a blow tube installed. I've got insurance. I do have to get a car seat. I'm looking at that today. I'm not working yet, so I'm still trying to work around income. So I'm hoping that I can find some resources for a car seat. But I think it's gone really well. I think I'm learning how to deal with my son's outbursts, or like, to calm him down, or, different ways to work through some things when he gets a little overwhelmed. But I feel like overall we've worked really good as a team because we're the only parents he's ever known. So I think it's going really well.
Okay. I want some honest replies to the question I'll ask, but a couple of years ago, the court entered this phased visitation plan. So phase 1 would be Ms. Johnston with the child, and I take this to be unsupervised, every Saturday and every Sunday from 10 to 3. And she has to continue on her compliance with treatment. That is supposed to last for a period of 2 months with no relapses. Ms. Gill, do you think we're ready to move to that stage at this point?
I think we're really close. I would like at least maybe one weekend visit where we spend the whole time together with me and him. My only concern is the 2 times we've went there, there's no one home. So I do know that once it might be a little challenging for her as he's there and there's more people, but he's gonna have to, he's gonna have to learn how to deal with that. But I would hope for maybe just one more weekend together, spend it all over there. And then, because I have been talking to him about how soon he's going to have visits with mommy by himself. And he said he was a little scared. And that's why I had decided to go over to her house the last couple weekends, because I thought it would help him out a little bit. But besides that, I'm pretty confident and ready for him to start doing that, because I think it would be good for them.
That's fine with me. I'm even okay with it being like 2 more weekends if she wants, and then maybe like, cause on the phase 1, I got it in front of me. It says Saturdays and Sundays. So like if we want to split it up again, even like this next weekend, say like, how we did the last weekend, half and half, if we can try that, I'm up for that. I do agree. I think it would make him more comfortable. And then, once he is more comfortable in because he came over and he went through all of his toys that I've had of his the whole time. And he got really excited and he got to ride his new bike. But I think we didn't really get to sit down and really just like, maybe put on a TV show or anything like that. So I think maybe, the next 2 visits, if we work on that a little bit more, and I think it would be good for him.
So first of all, I'm very happy that we're now at a point where we're about to implement what the court put together a while back, and that took a lot of work on everybody's part. So I want to acknowledge that. Let's say 2 more weekends together, but it will be Saturday and Sunday 10 to 3. Will that work with your schedule, Ms. Gill?
It makes it a little hard just because I usually use Sundays as our day of having to do grocery shopping and housework, because half of one of my days off is spent with the visit. I wouldn't mind if maybe this weekend we do Saturday for the 4 hours, and then next weekend do Saturday and Sunday. And then after that, let her continue. And of course, I'm always one phone call away if she ever, needs anything. And luckily we live only like 5 minutes apart. So that's really nice.
Okay, let's do that. So Saturday will be 10 to 3. A week from Saturday will be Saturday and Sunday 10 to 3. And then the next weekend will be Saturday and Sunday 10 to 3, unsupervised. And you mentioned you're a phone call away. I would like you to be on call should there be something that Ms. Johnston runs into that she needs assistance with. And Ms. Johnston, I don't want you to feel that I'm going to unwind all of this if you make a call saying, I don't know how to handle this situation. I'd rather you do that. I'm committed to seeing you get through these phases. Okay.
Yeah, I 100% agree with you too, because like I've told her, I'm still learning so much. And it's only been this last year that I've even realized he had any sensory issues or autism was even, a factor. So I'm still learning. And that's why I always want it to be open, that she feels comfortable to call me in those things, because I'd rather her call me trying to work it out together than him continue with a meltdown. And then it's just no fun for anybody.
Okay. I'll put together a bench order indicating those modifications. Otherwise, I'll say that we're going to start phase 1 of this plan. Let's get back together on April 25th. That's about 2 months from now. That's when this plan, the phase 1 would end and we'd go to phase 2. I want you to know, Ms. Johnston, I'm going to require a hair follicle test as we move from one phase to the other. So if you want to do that before April 25th or shortly after that, as you go from one phase to another, I'm going to require that each time you make the transition. Okay.
Okay. I just have a few questions. So in our order, it does say that she can request a hair follicle at any time and all that. And then if it's positive that she pays for it, or no, I have to pay for it. If it's negative, then it's got to be reimbursed. If we
Right.
can that I'd be appreciative of it, because I don't have an income right now, and I've paid for the last two that came back
I
negative.
never was paid back for the positive one though.
And that's why I paid for the first one. So I'm just saying from here on, if we're gonna do that each phase, like I can figure it out. But
Okay,
like,
I don't think I'm going to agree to that, because I'm ordering the hair follicle as we go from transition to transition. It isn't something that Ms. Gill is asking for.
okay. And then as far as when we move into this phase, or going back to the order, as we start trying to get back into that,
Right.
if at any point in time I want to get in front of you again for some reason, for any modification, anything like that, do I have to file a different, is it going to be under the minor guardianship?
Right. All this will be under the minor guardianship. If either of you feel you need to get back in court sooner, say than April 25th, you can do that. But I think it's unlikely I'm going to change from the phased program that the court put together. So the next phases, I believe, are each 6 months long. So they're quite a bit of time. I'm probably not going to rethink that. I'm going to require that we go through those different phases. Okay.
So in our phase 4, it does say that at 18 months that I can ask for a modification of me being clean. 18 months would be next month. And I have this, the reason I even had to bring this to court was because the plan wasn't being followed by the other party. And I think we're working really good together now. And I do think that the phase part, but there's just a couple of things at the end of this agreement that I don't think are right anymore. So maybe like in 6 months, could we think about that, depending on how things go? Because it goes from me having him every weekend through these phases and overnights to me only getting him every other weekend, and that doesn't like transition me into like decision making or like school or his therapies or anything like that. And if he is say this plan and we're going to be transitioning him back home eventually, like this plan doesn't actually have any of that in it. And so I feel like it needs to be adjusted later on for that to start having us work together more with those decisions and the school and the therapy, and for me to learn all of it and be a part of it for when he does come home.
There's a saying that you're getting ahead of your skis, and I think that's what's happening here. First of all, I don't think the 18 months kicks in until you get through all 4 phases of this program. That was the contemplation of the court, is that you would get through phase 1, 2, 3, and 4, then you'd be able to petition for custody at that point. Right now we're in phase 1. I understand things might have to be adjusted, and you can always talk to me about that. But right now, let's get through phase 1. Let's do the plan as it calls for. And when we start phase 2, we'll see if there's anything else we need to address at that time. Okay. Everyone's doing really good. Let's just not try to push things to where we start feeling uncomfortable. Okay.
Yeah.
Okay. All right. I'll do the order. I'll see you back here on April 25th, and good luck. You're going to spend time alone with your son for the first time in a long time. And I hope that goes really well. Some visits that have gone on. Ms. Johnston, how have those gone?
Sorry about that.
Thanks for going through that. So my question was, how have the visits been going? Ms. Johnston, you can go first.
Okay. I think the visits have been going great. Me and my sister I don't think we've ever been able to work together the way we've been working together. And it's been a huge blessing. We've really been able to come together for Gage's needs, and we've been making sure to make family time for him when I feel there's a need that he needs all 3 of us there, and to just reconnect and know that we're all a unit. He's adjusting well to being in my home and being with me longer periods of times, and he's comfortable there. So in my opinion, they're going great.
All right. Were you able to do a UA prior to the hearing today?
No. Was I supposed to?
Well, we'll talk about that.
Okay, because I can.
No penalty for not doing it, but we'll talk about that.
Okay, sorry about that.
Ms. Gill, your impressions?
I think it's gone really well. I agree with Charity that this is the first time in almost 5 years. I'm sorry to get emotional. It's the first time in almost 5 years where we're a team for Gage. I feel, finally sees that I am a parent for him just as much as he or she is to him. And we've come together with that because he needs to see that. We have been able to work through things where if like a birthday party came up and we need to alter the time frame, she's been willing to work with me on it. I've even had like special appointments where I've given her an extra day with Gage, an extra time, so that instead of him being with someone else, it just offers her that chance to have with him, which I think has been wonderful. I know as of right now, my only concerns are if I need to submit for a summer schedule, because my worry with Gage is it takes him a very long time to transition and adjust to things. We got kicked out of the Parks and Rec program for after school because he just really couldn't handle it. And I don't want him to spend the entire summer in a fight or flight mode. I want him to enjoy his summer. So her and I have kind of talked about possibly her having him on 2 weekdays instead of the weekend, so that I only have 3 days to have to worry about his care for the summer. And my only other thing I would like to maybe suggest is, I know that you said you weren't very willing to adjust our schedule. I just feel at this time, if of course it's all right with you, I would like to maybe shorten her next phase, but in like extend the phase after. I just feel that it's been almost 5 years since Gage stayed the night with his mom, and it's getting very emotional on him. And as much as I do think she needs to have some 8-hour visits under her belt, before the weekend visits, I really think it would be best for Gage to do maybe 3 months of 8 hour visits and then move to the phase 3, but have it be, instead of 6 months, 9 months of overnight visits. I never thought I'd be in this position where I'd be willing to make an adjustment like that. I've been, very protective of Gage and his emotional needs. But she's made such progress that I think they both need this. And it breaks my heart. She put him to sleep Friday when she had him extra time, and he lost it. And he just said, "When do I get to stay the night with my mommy?" And we keep telling him, "Well, we're working towards it, buddy." But he can't grasp that at 6. And so I know she'd be willing for that. And if you're willing, Your Honor, I really think that would be the best option right now.
Well, I was looking at going to what is phase 2 under the former parenting plan. And that would be 2 8-hour visits each week. These were set for Saturday and Sunday. It sounds like what would work better for you is 2 weekday.
Once the school year ends.
Okay. Well, that's coming up fairly soon. Here's, I'm going to make a couple modifications to that. And as you both know, this was to last for 6 months. So until, when does school end? Is that mid-June?
Yes. I can't remember the exact day. I know we're down to like 20 something days.
Okay. So let's go to phase 2, but I don't think we need to come back to court. I'd like you to do a UA, Ms. Johnston, in the next couple days.
Okay.
Before this weekend, and show the results to Ms. Gill.
Do you want me to do a UA or a hair follicle?
I think my notes said a UA was going to be sufficient.
Okay.
For what we needed. So if you could do that, give the results to Ms. Gill, assuming that it's negative, then this weekend we'll start phase 2, which is 8-hour unsupervised visits Saturday and 8 hours on Sunday. That will go until school ends.
Okay.
And then whatever 2 days a week you decide, they don't have to be consecutive. But whatever 2 days during the weekday, that will take the place of these 2 weekend day visits. But I also want to add in there one additional 8-hour on like 2 or 3 weekend days a month. So you could do the first and third Saturday, say. A weekend day is a little bit different, a little bit different rhythms, and I want Ms. Johnston to spend a little bit of the weekend time with Gage. Okay, so that's going to add a little bit of time. Again, if you want to do the first and third Saturday, then add that to it. I will take your suggestion to have that go for 3 months. And so we'll pick a review date in 3 months. So let me take a look here. That'd be June, July. So that would be.
I just want to say thank you. In
I just
advance.
want to tell you ahead of time, but we
Thank
worked
you.
really hard.
I'm just really glad we're at this point where we can work together as a family.
3 months would be September 5th, which is the day after Labor Day, if that will work.
Yeah, that's fine with
And
me.
then we will look at going to phase 3, which is going to be overnight visitations. And it also is probably a good time to look at what Gage's school schedule is and to see how all of that will fit well. And sounds like both of you are communicating well. So if you came to me on September 5th and said, here's the schedule we want to do, I probably would agree to that. Okay.
Okay.
All right. File that UA
Okay.
with the court, but more importantly, make sure Ms. Gill gets it. Okay.
Okay.
All right. Any questions, Ms. Gill?
No,
All right. Thank you.
Thank you.
thank
And
you.
Ms. Johnson, I'm very proud of you, and I think you should be proud of yourself.
Thank you.
Okay.
Thank you.
All right. Take care. We'll see
Yeah.
you.
All right. Bye-bye.
I guess the first question to Ms.
We're moving along on a visitation schedule. Where do we stand?
I think the whole point of today was because he couldn't open the schedule up for next year to place a date in, I think, March for us to come back after our 6 months of this phase that we started in September.
Let me look at the order here. Is that visitation schedule going on at this point?
Yes.
Yes.
And so other than just that review date, anybody have anything else they think needs done at this point?
No, I don't think so.
All right.
I have had a few issues recently, and I don't know if we should address that at the next one or here.
What kind of issues are we talking about?
One, the first thing I wanted to ask is, I don't know if it's the same for all court cases, but I wanted to see if there was an option of getting a court-appointed attorney for me. I can't afford one on my own, but I just thought I would ask because this case has gone on for so long and I definitely need some assistance with it.
Making that request in writing, and then we can address it.
Okay.
Okay. And we'll set the review hearing for March the 7th, and that'll be at 10:30.
Okay, March the 7th.
Yes, and get your motion filed well before then, if that's what you're gonna do.
So, Your Honor, we were going to request a set over. I was just appointed. The case is quite voluminous, so I haven't had a chance to go over it. Additionally, in reviewing the orders, my client's at the point where she can now petition the court to transition the child home. And so that is a motion that we need to file. So my thought was set it over to give her time to do that, so then we can come back to court and start discussing a plan to transition home.
Let me ask a question, Ms. Gill, from your standpoint, how are the visits going?
Not well since November. And in my understanding, she's not allowed to petition the court until we are in phase 4 or doing phase 4. But Things were going really well up until November. Her and I were working together. I even petitioned to get her overnight visits months before she would have originally been allowed. When November hit, Gage was introduced to the third man since December 2022 as a new boyfriend. She then started taking him to overnight visits at the boyfriend's house out of town, where she will not disclose the address to me or allow me to pick him up from.
And Your Honor,
claimed
we're gonna object.
I'm
That's
talking-
not true.
I'm-
She has the address.
All right, everybody hang on. Ms. Gill, go ahead and finish.
All right. So only up until I was given paperwork from the Superior Court did I know the address. It was accidentally put on a piece of paper. She still has not allowed me to pick him up or know where this address is out of town. But for months, she had been still claiming to me she was living at the Oxford house and doing overnight visits there and having me pick him up from a house she was not actually living at or staying at with Gage. The issues I have with him, where she's residing, one, not knowing where. Two, it's with a boyfriend that has just been released from prison within the last few months. And there's two other men living in this house, Gage has told me, that I do not know, a man named Tuff and his dad. There is no bedroom for Gage. He's been sleeping in her bedroom, which I don't think is right, especially if she's wanting to have more overnight visits with him. And Gage has been coming home more aggressive because he's been being taught how to box. The aggression at school has increased, and behaviors, to the point where the teachers have called me multiple times to ask if something else has changed outside of our home to cause the increase of aggression and behaviors. And not just with that, but he's coming home and saying that he's not allowed to call me his parent anymore, which he's called me his parent since of age 4, that he is only allowed to call me his aunt because this is all my fault that he's not with his mom, and that he's not my kid, he's her kid. And these types of things should not be discussed to a child at this age, nor a child that is already struggling with regulating his emotions at that regard. So we have had such a low level of communication because of all this and all these, secrets, whereas before she was so transparent about everything.
Your Honor.
Hang on. All right, Ms. Jocelyn?
Yes. So this is one of the things. I haven't been able to get into this. And unfortunately, what Ms. Gill is saying is just simply convenient at us wanting to reach out and move to phase 4. I called Ms. Gill 3 times, no response. I emailed her. She finally emailed me back on Monday. This is the first time that myself or my client has heard of this. It's just convenient that after we're talking about restructuring phase 4, that all of a sudden she's freaking out and saying all these things are happening. My client and her had a discussion about potentially changing phase 4, which is why I reached out to Ms. Gill. And then after the 3rd time of reaching out, when she finally responded, and I have emails, we can send it to the court, she's like, no, that's not the agreement. So this is part of the reason why we need to have a set over. I need to get a clear understanding of what's going on. Nothing, Ms. Gill has filed no declaration stating any of this. My client has no chance to respond. She's made no complaints. She's made no motions before the court to change anything. It's time we move into phase 4. My client's going to petition to have the child transitioned. And I understand my client is very thankful for Ms. Gill. And we've understand that my client and Ms. Gill have been together for a long time. And unfortunately, part of this is Ms. Gill is upset and having the child is transitioning back. My client has no desire to cut Ms. Gill out. And once he transitions back, still wants her to have time, whether it's every other weekend or a weekend. So my client, unfortunately, with having me just retained, having no information before the court, she can't properly defend herself when nothing that's been said is in any documents. So that's why we're requesting a set over. And then we were going to also file a motion to modify phase 4, because that's not, from our position, not the most appropriate thing for phase 4. So I think a set over of a month would be appropriate to give us time to do that. And then if Ms. Gill has anything she wants to file, she can file it in the appropriate time frame. So my client gets a chance to address it and not have it sprung on her.
Okay, here's what we're going to do. I will put the matter to April the 4th at 10:30. I'll put it at the end of the calendar because there may be a necessity for some testimony. In the meantime, Ms. Johnson, the visits take place at your home, period, end of conversation. Ms. Gill always knows exactly where that child is at any time. Is that understood?
Yes, Your Honor. I live with my significant other, and I told her.
Okay, Ms. Gill or Ms. Johnson, hang on. Whoever else is in that house, you need to make sure Ms. Joslin has all that information. You need to make sure Ms. Gill has that information.
Absolutely.
What's going on with UAs since you're not in the Oxford house?
I just did a hair follicle. Unfortunately, I had it done and I had it sent to all parties. I did forget to file the copy with the courts. I did file it this morning. I apologize for that. I've been gathering all this information, trying to get it with my attorney. So I'm a CDL driver. So between my work schedule and getting everything from my attorney, I did forget to do that, but I did it this morning. I've been clean for 29 months. I've got a career now. I'm doing everything. My son is thriving under my care. Like
Hey, ma'am, hang on.
It's Your Honor, to make it easier, she filed, Miss Gill and I got a copy of the hair directly from Omega Laboratories. She took a hair follicle on 2/22. That was filed today, Your Honor. It is negative for amphetamines, meth, coke, opiates, phencyclidine, and THC. My client also has a multitude of UAs that I'm in the process of gathering. I wanted to file it all at once under seal so the court had the total so we didn't have to go back. But for example, one UA I'm looking at right now from 1/18 of this year, again, negative for everything that was screened for.
Okay.
And so,
Your Honor, I have a question about the drug tests also. So in our original parenting plan, it states that I can request any type of drug test and I have to pay for it ahead of time, right? And that if she's negative, she has to reimburse me, which she never has. And if it's negative, I pay it, excuse me. If it's positive, she has to reimburse me. But in September, when we went to court, she asked for it to be changed. And
Okay,
for
so what's
her,
your question?
so my question is back in September, if it was modified, because she asked for it to be modified, that she'd be willing to pay for any tests I request, because I don't ever really request them. And the judge in September said that they don't normally do that, but because we were working so well together and he didn't think I'd take advantage of it, that he would put that in the order that she would pay if I requested it. Well, I requested a hair follicle on the 2nd of February, and she refused unless I paid for it,
Okay,
stating she never
hang on.
said that.
Hey, everybody hang on. Okay, the order says respondent shall UA hair follicle upon request at her expense and must provide a follicle test before review for phase 4 in 6 months. So that's still the order. And if somebody owes somebody, that needs to be taken care of.
Your Honor, I think what she's asking is that was a one-time, that was not saying moving forward. So my client did pay for the hair follicle and that's what she filed today.
All right, well, this one doesn't say one time only. It just says upon request.
The judge said,
okay, I'm getting tired of getting interrupted.
I'm sorry.
The secret.
It says upon request. If there has been just one request in 6 months, it's not being taken advantage of. And from Ms. Johnson's standpoint, a current one would probably be a brilliant idea for that hearing in a month. Pending that hearing in a month, Ms. Gill knows exactly where the child is staying at all times. She knows who's in that house. She's entitled to go visit the house if she wants. She's not going to be a regular guest there, but she's entitled to know exactly what's going on. I'm not going to have anybody hiding anything. Everybody understand that?
Yes, Your Honor.
Your Honor.
All right. So April the 4th, and it would also be a good idea from both sides' standpoint to provide some sort of pleadings and affidavits showing where things stand now. So whoever's hearing this has an idea what the issues may be.
May I make a request, Your Honor?
Yes, ma'am.
Yeah, I was wondering if we could do pickups and drop-offs at the local DSHS office, the CPS office. That way there's less conflict. There's been
If you guys can't get along for the pickup and drop off, I want to know about that. Everybody gets to behave like an adult, and anybody who can't, that tells me an awful lot.
That's been part of our issue recently is she
Okay.
keeps attacking me during pickups and drop offs.
Did you hear what I just said? If anybody can't behave like an adult, that's important information for whoever's hearing this.
Okay.
All right, the floor is at 10:30.
Perfect. And I'll work with the parties about pickup and drop off, Your Honor, and try to smooth anything out.
All right. Thank you, counsel.
Thank you.
All right, we have two matters on. I'm going to take the Gage Johnston matter 22-4-00454-08. I'm not able to hear that matter, so it is going to be set over. And I'm sorry, Ms. Jocelyn, you were saying to what date?
It's set over to 4/16, Your Honor, on Judge Basher's docket.
Okay.
And we sent a citation up yesterday. It'll probably take a few days to get into the court's file because we mailed it up.
Okay. So if you are here on the guardianship of Gage Johnston, that matter is going to be set over to April 16 at, I'm assuming he's at 10:30 as well. Yeah, 10:30 a.m. So again, the Gage Johnston matter is being set over to April 16 at 10:30 a.m.
Thank you, Your Honor.
All right, is on the Charity Johnston and Gage Johnston matter. See Ms. Gill
Your
is
Honor.
present. Good morning. Ms. Jocelyn is present.
And Ms.
Okay.
Johnston is present as well on Zoom. She has the red box with the C.
Got it. Okay, thank you. And we do not have a visitor on this case. Do we need one on this one?
No,
I
I
think
don't
so.
believe so.
Okay, so where are we at on this one, Ms. Jocelyn?
So we were supposed to move to phase 4 in March. My client had a phase 4-phase visitation schedule, which once she got into phase 4, she could then petition for the child to come home. I got appointed in February, and when we came to our hearing, I believe it was March 7th, Your Honor, we'd indicated that we wanted to amend the phase 4 schedule. And so it has been put over. We filed our motion to amend the phase 4 schedule. So that is what's before the court. Also, phase 4 hasn't started. So we're here today on our motion to amend the phase 4 schedule. I know that the guardian had also filed a motion, but she hasn't cited it on.
Let me see here just a second.
Yes. And for ease, our pleadings were filed March 14th.
All right, and I did receive those, Miss Gill. It looks like those were filed and we received a copy, at least here, April 10th. That doesn't have a hearing set. Let me see here.
I didn't know I had to set a hearing. I just guess I was thinking I had to submit something as my side of it. So that's on me that there is no court date for it.
And I had tried to ask Miss Gill what she was trying to do. Is this a response or a motion? And she wasn't very clear. So certainly she has her right for the motion, but she would need to cite it, give us notice.
I guess my concern on this case is when I look back through this, this looks like something that this started back in October of 2022. And it was there ever a guardian ad litem in this case?
Yes.
Yes,
this
and then they
actually-
were dismissed.
The guardian ad litem was dismissed when I got final order for guardianship.
Okay.
The original case started back in 2018. And then when the laws changed, they told me in order to be seen in front of the judges again, I would have to file a minor guardianship because we could no longer file into the other case. So it's an extensive,
Right.
it's going on for a long time.
Right. Yeah, this is one of those that got caught in the middle.
Yeah.
All right. So I guess my question, and again, this is one of those, I was just trying to make sense of it because it was a bit of a kind of a convoluted history because of that.
Yeah.
There were a couple of different orders.
So for the final orders, Your Honor, in terms of the final residential schedule, while they were made, I believe in 2019, if you look into this matter, they were filed under cover under December 12th, 2022. So they were filed into this case, but there were actually orders that were made earlier. They were just made in the third party case. And so that order that was filed December 12th, 22 outlines the 4 phases.
Okay, and we're currently in phase 3, as I understand it.
Yes, we're supposed to
Yes.
move to phase 4 in March, which the parties haven't. We had, and I believe that was because we indicated we were going to be filing a motion to amend it, phase 4. There's been no objection, so I think at a minimum, depending on what we do today, we need to start that if we are going to appoint a GAL.
I
But
do
my
have
client,
major,
hold on, sorry, I'm not done yet. Thank you, Ms. Gill. So we do have the motion today before you, Your Honor, to just simply amend that phase 4 schedule by a couple of nights. And that's what we have before you. I'm not 100% sure with everything that Ms. Gill filed, what was actually supposed to be in response. So what I did was took her first declaration that was 12 pages long and utilized that as a response. And so my client wants to proceed on the motion today.
Well, so is this a motion for adequate cause to modify?
It's just a motion to amend the schedule for phase 4. Since we're in phase 4, we had discussed it at the hearing in March, and they said if we want to amend, to file a motion.
The reason we did that is the way the plan is set up, phase 4 goes from me having him every weekend to me having him every other weekend. And with the connection and the relationship that we've built, I think it would do more damage than good to go to every other weekend because he's used to seeing me every weekend and he's been asking for more time. So we went ahead to try and amend it in his best interest so we don't lose that connection and the establishment of mother role.
my only concern, Your Honor, is that our original plan states that she cannot have overnights before having adequate housing. And 2 weeks ago, I was notified by the person that owns the home she was living in that she was squatting and was not a tenant and she was evicted. So the last 2 weekends, she's been camping in her boyfriend's family's yard, which I do not think is adequate housing to have her overnight visits. It's very concerning. He needs stability and routine, and camping is not appropriate. I've submitted documentation of the text message I received on Facebook from the owner of the home. And I also talked to her about that. But I don't think it's appropriate to be camping every weekend when you're homeless and you don't have a home to take your son to for visits.
Your Honor, I'd like to say there is a civil matter between us and the landlord. I have had to call the sheriff multiple times, and every time they come out, they tell us this is a civil matter, that she has not served any eviction papers. She has not done any of the legal actions that she needs to do in order to have us leave. We are currently looking for a new apartment. I have scheduled meetings this week with 3 separate landlords. I am currently staying with family in an RV that's got a bed, it's got a shower, it's got a kitchen, it's got everything that he needs. It's not ideal, no, but it is adequate enough to continue my visits. It's only temporary. I am moving as fast as I can. We still have all legal rights to be in this home out on West Side Highway. I just have chosen, because of how hostile it has gotten between the landlord and us, to not put my son around that, because he doesn't need to see anything like that. And they have been very aggressive and hostile. So for his best interest, I've just moved the visits to family where he's safe, where the people here are approved through CPS as guardians, and they're mandatory reporters. So everything is safe for him. I'm doing all I can to get into an apartment as fast as I can. I've got all the money for it. I'm just waiting on the approval from the landlords.
Okay, and you have a valid license and insurance, yeah?
Yes, I have a CDL license right now, Your Honor.
All right.
Yeah. So that's why we brought this, Your Honor. It's not that she's trying to make some crazy adjustment. It's just with her current plan right now, she gets every Wednesdays after school and every Friday overnight. And phase 4 has us going to every other weekend, Friday to Sunday. So it's the same amount of time, it's just allocated different. But the whole point is to transition Gage home, and going to her seeing him 3 times every week to 3 times every other week is going to be detrimental to that bond. And so we're just simply asking we had 2 proposals for a schedule, either adding on that Saturday every weekend for the first 3 weekends, or doing like a Friday to Sunday one weekend and then Friday to Saturday the other weekend, to kind of keep that bond up. And I think it's important to note, Your Honor, until Charity had me appointed and we started conversing in March, these issues hadn't been brought up. These alleged issues hadn't been brought up to the court. There was no motion. There was no request for a GAL. It's just when my client finally put her foot down and said, I want to move forward, it's time for my son to transition home. That's when the guardian started getting upset, which I get it. She's had him for 5.5 years. I get that there is a strong bond and everything, but it's gotten to the point where, due to the guardian's actions and her harassment and her hostility, my client had to file an anti-harassment order against her to get her to sort of calm down. And I understand, I really get it. It happens a lot when you have a child for that long. But at this point, we have to work on transitioning home. It's not appropriate for the guardian to be saying, you're my son, I'm your parent, this is not your mom.
I don't say that.
Excuse me, Miss Gill, if you could just wait. It's really like sad at this point. It's just, now we don't want to move forward. So we're simply asking to add those additional time and proceed on our motion today. Of course, we do have more to say than, just that. I just wanted to give the court a brief overview.
Okay, well, I guess here's the concern I have. This is a court order that was put in place back in 2020. I assume there was a guardian ad litem that may have had some impact on that proposal or that phase system. And I think absent a guardian ad litem input on, it seems to me we're on this, if she's complied with phase 3, then we move to phase 4. But if you want to change phase 4, I'd want to have a guardian ad litem look at it.
Okay, then we would ask we move into phase 4 today, and that, and if we want to change it, I'll speak with my client afterwards, and we'll talk about appointing a GAL. So we would ask that phase 4 starts immediately, which includes her Friday to Sunday starting this week, and then I'll discuss with her about amending phase 4 and appointment of a GAL. There's been nothing before the court that's been brought that says stop phase 4 or anything like that. We even have the guardian who wants my client to have every other week in the summer. So, Your Honor, we'd ask that phase 4 then starts immediately, and then I'll speak with her about amendments and appointment of a GAL to amend that.
Ms. Gill, and I did review your and it, I think there's some concerns raised. I don't.
And I did file a response to that, Your Honor. It just hasn't come across for you to be able to see it yet.
All right. So here, I guess here's where we're at. If she's completed the 6 months under phase 3, then we move to phase 4. And then if there needs to be some adjustment under phase 4 or some other issues, that can be brought back before the court, and we could take a look at a guardian if we need that.
Thank you, Your
So-
Honor. And just to note, my client is also 31 months sober this month, and she submitted all of her hair follicles in UA. And then just to be clear, Your Honor, since it is an every other weekend phase, can we have the order that her every other weekend starts this weekend?
Ms.
Your Honor,
Gill,
my
Go
only
ahead.
concern is, so I am not opposed to having more time. My problem was for like 4+ months, she would not tell me where she was taking him overnight, which caused more and more problems because I wasn't allowed to even know where he was at. And I really do not think it's appropriate to go up to more overnights, sleeping in a camper in the middle of Kelso or sleeping in a field out of somebody's yard. If she's really trying to be responsible and get her son back, camping every weekend is not appropriate. And it's not stability for him. You know, he's not getting baths, he's not eating, he's not getting homework
And
done.
that's not true,
Your Honor,
I'd
we're
like
gonna-
to
Well, hold
stop.
on, hold on, okay. If he's camping for every other weekend, that's certainly not gonna hurt a child of 7 years old.
Yeah, the only reason we actually went
Ms.
camping.
Johnson,
Sorry.
just sit tight for a minute, okay? Okay, you've got an order in place. We're gonna follow the order unless I see a reason. And if we want to modify that, then I want to go ahead and invite him to weigh in on it and see. This was put together 4 years ago. I assume a lot of circumstances may have changed, which may change that order, but I think I need to see something that indicates that.
Thank you,
So,
Your Honor.
if it's been the 6 months, then we should switch to phase 4, which would start this weekend.
Thank you.
So it'll be every other weekend, Your Honor?
That's what it looks like in the order, phase 4. I'm looking at the order it's in the.
Yes, Your Honor. It's every other weekend, Friday to Sunday.
And not Wednesdays. It's just every other weekend in our order.
Wednesdays was granted to me under the minutes in a previous hearing.
I'm looking at the order that's in front of me, which is the order we're working under, which talks about what phase 4 is.
Yes.
So phase 4 is whatever it says, and I'm trying to locate it here. Yeah, phase 4 also includes the language for adequate cause if that's completed as it states. And it's basically every other weekend is what it indicates there.
I believe, Your Honor, what my client was referring to is after this. I'm not sure if it was I think it was Commissioner Nelson. There's a bench order that adds on every Wednesday. So there's a subsequent bench order from Commissioner Nelson that adds on the Wednesday visits.
You know where that is?
Yeah, I'm gonna if you give me one moment. Right now. September 5th, 2023 bench order. And then let me open it up. I believe it looks like Commissioner Nelson, but it is a 2-page bench order and it's handwritten.
I have that. Let me just a second here. So that does, it looks like it adds Wednesdays 3 to 7, or it could be from 2:15 to 7. It's not, I mean, I have no idea what the intent of that was.
That was just me offering more time during phase 3 for her.
Was unfortunately not the intent. It was to offer additional time. There's been nothing stating no Wednesdays. So we would just ask we move forward with phase 4, continue the Wednesdays, and either party can bring it back if necessary.
All right, that sounds appropriate. I mean, again, I don't know what the basis for that change is. If it was an agreement, that's one thing. So that would stay in place, and then we go to the alternate weekend starting this weekend.
Can I ask a question real quick?
Sure.
Could I, on the weekends that I don't have him, there is a protection order, so obviously I can't call Miss Gill herself, but I was wondering, could I have at least like some video visits maybe on Saturdays and Sundays through if my boyfriend calls Carmelo's phone?
I'm gonna leave it as is unless we have some, and if you want to modify it, we can certainly look at that and get a guardian appointed and determine if that's appropriate.
Okay.
Your Honor, The only issue also I have is I have alleviated her pickup by allowing her to pick him up from school, but she's been changing my pickup location every weekend. We were meeting in Four Corners in Castle Rock at a general store in public. And then once she started camping, she wanted me to meet her in Longview, or she wanted me to drive to Kalama and meet her. And I would like to just have one place I could please pick up so I'm
Makes
not
sense.
messed with.
Is Four Corners was the prior place everybody was using?
Yeah,
It
that
was,
over a month.
Hold on,
No.
Your Honor, hold on, Charity, hold on. The order, Your Honor, says, picking up parent, or picking, like we see in parenting plans, picking up parent at residence or school. So that's what the transportation order says. And that's, it's all the way back in that final residential plan. It hasn't been amended. We can certainly like work on it, because I think having one solid place, and I've tried to work on this with Miss Gill, either one person's going to pick up or always going to have a halfway point. The problem is she wants my client to pick up and she wants a halfway point. So I believe we need to stick with what the orders say, absent an agreement. And the orders say picking up parent or guardian. And
There's a
so
protection order now, though.
there's a carve out in the protection.
Yeah, there's an exception for us to have contact for pickups and drop-offs.
Okay, what is the protection order case number?
Let me 24-2-00726-08. I believe that's a 7.
That's not, wait a minute here.
Or maybe that's a Z.
I have it, Your Honor. It's 24-2-00226-08.
Thank you.
No problem.
Sorry.
Let me just look at that. I want to make sure we don't get either of you into any trouble. So let me look what that says. Looks like that's actually in the process of the hearing on that next week.
Temporary order is issued 3/14. It's been continued a few times.
Oh, I see. Okay. Let me see.
And I believe what happened is at the initial temporary order that was issued on the bench, Your Honor, didn't include the carve out. They went to the hearing and alleviated the carve out.
Direct contact between parties allowed for child pickup and drop off between the parties.
Yes.
So here's what I guess what we'll do. Well, I guess here's the problem. It looks like when that order was extended on April 8th, it did not include that carve out, even though I think the carve out would still be valid, but it still could result in a law enforcement interaction because it's not in the order that they're going to be looking at. And I don't know what changed that here. So
Before the exception was put in, Miss Gill and my boyfriend David Lee were doing contact to do exchange. That was working out really well. Both of them were civil to each other. I think that could be agreed upon to stay if that's the situation.
Yeah, I was meeting him at Castle Rock, and because we were 20 miles apart, our houses at the time.
okay. So I guess at this juncture, I'd be concerned about having direct contact because of the wording of that extension order. And that's not back on for hearing again until it looks like next Monday. So whatever happens next Monday, if there's an ongoing order that needs to have some language in there about this issue.
Okay.
Whether it's a permanent or a temporary, but between now and then, I think going through the boyfriend probably makes sense to make those arrangements. And then Ms. Gill, if you and Ms. Jocelyn can discuss an agreement on the transfer a location or something. It seems to me having one place that everybody goes to all the time makes the most sense. That's not really a change in anything other than dealing with this new situation with the no contact order.
I've not
We've
had
been
very
doing the
much luck
mall.
dealing with Miss Jocelyn on that. I've asked for weeks now to have a concrete pickup, and she pretty much tells me, I'll check. You need to get a hold of them. You need to get a hold of them. And
Okay,
it's
well,
just changed on me.
well, hold on. Where's everybody? Whereabouts do you live at, Ms. Gill?
I live in Longview, right by the lake.
Longview by the Lake. I mean, Ms. Johnson, where are you living at?
Right now, because of the issues with the landlord out at West Side Highway, I am staying in Kelso on Elm Street.
Okay, so pending getting a resolution in this, why don't we have you do an exchange here locally instead of driving to Four Corners or something?
Yeah.
Maybe we use the McDonald's on Ocean Beach, the one downtown, not the one out on Ocean Beach.
By the dollar store?
Correct, correct. And that's a reasonably good place because they're always open. They have cameras there, so it's a reasonably safe place.
I agree.
Okay.
And is that only for the exchange at the end of visits? Because my client picks up at school, or do you want the child to be picked up from school and brought there?
I think it's probably, if you pick it up from school, that makes sense because it's not any interaction between the parties, but for the return, let's do it at McDonald's in Longview and that'll save everybody some drives.
Okay.
Perfect. Thank you.
Thank you, Your Honor.
So then on this case, we don't need to extend any orders because there's already, we're just waiting for, do you want to set another review on this or just let it go at this point and see if anything needs to be filed?
I think at this point, let it go, Your Honor, because they have avenues, like you stated before, to re-cite it on, but they also have provisions of what my client needs to do to ask for the child to come home. So I think at this point, just follow the orders and cite back on if needed.
Okay, so that, the only thing I would indicate, it might be useful to have something indicating that that exchange place will be McDonald's, just so there's clarity there. If not, I mean, I don't think we have to have that, so.
Your
No,
Honor.
I think,
Oh, go ahead.
Yes, ma'am.
Go ahead,
My
Ms.
only other concern of why I do want it reviewed is because them wanting to modify phase 4 doesn't take in consideration that Gage is going to be out for summer break. And I think that there should be a summer schedule in place to where it's not just weekends that she has him. She'd have more responsibility of him, which would be helping benefit her for a transition home. And that's why I was really hoping that there would be like a guardian ad litem, just because it's a very awful position for me to be put into to hold her accountable. And with the protection order, I can't even ask her for UAs anymore or anything like that. It's really like put a bind on what I am allowed to do or contact her about. But I do think that we need to have it revised for a summer schedule for him.
and I'm happy to work with Miss Gill. My client will do the week on, week off that she proposed, but we do have the phase 4 that states what my client needs to do and what is the basis for AC. So at this point, she can bring it forward. If Miss Gill still wants to do the week on, week off, I'll talk to my client afterwards and we can reach an agreement and send a stipulation into the court. I don't think there's a need to review this.
Yeah,
nothing
because
in
the
the
order
plan.
doesn't state a summer
Hold on,
schedule.
Charity, hold on. We have the orders in place and each side knows what they need to do if they need to modify it. This was a plan to set forward. I will talk with my client after this hearing about week on, week off. And then I can send over stipulation to Miss Gill to sign to convert it for summertime for that. And we can agree on a pickup and drop off time and day.
I was only willing to agree if a guardian ad litem could investigate wherever he would be staying.
Okay,
Because
let me stop you both. So this, I've got phase 4, which talks about 18 months for something.
For me to be clean that long, and I've been clean for 31 months.
Ma'am, I can read. Okay. So
Sorry, just
I don't know when that runs from, if that runs from the phase 4 starting or if that starts from some other point. So that may be an issue, but in any event, the phase 4 is a visitation schedule. It doesn't say a week on, week off. So if you guys agree to something else, that's fine. If you want to bring it back in, we have a guardian appointed to look at a modification of that. That's fine too. But right now it's phase 4.
Thank you, Your Honor. And
Okay.
just for housekeeping, as I was appointed, does the court want since we're done, does the court want to relieve me today, or how does the court want to handle that moving forward?
Absent there being any, I guess my thought would be is, why don't you talk with your client, see if there's any need to do any adjustments of any kind, because it'd make more sense to just deal with that than go through a reappointment process if we need to.
Okay, thank you, Your Honor, appreciate it.
Okay, if there's no need to, if you want us to send in a final order relieving you and with the billing, we
Okay.
can take care of that.
Okay, thank you, Your Honor.
All right.
Thank you, Your Honor.
All right, good luck.
Thank you.
So going back to the other matter, which was before us today, which is the Gage Johnson matter, 22-45408. And I see Charity Johnson. And I believe I saw Miss.
I'm here as well. I just got to figure out my camera.
Okay, I thought I'd seen you sign in, so I did see you there, and I did receive your response. So I guess it'd be to Charity. Wait a minute here.
Your Honor, I represent Charity Johnston, Miss Joslin.
Gotcha. Okay.
And we did receive her response. We just wanted a little bit of guidance from the court. She filed this less than a week before, so my client did get a chance to review and reply. So we'd either ask the court to strike her response, or in the event that they don't want to, if the court gives us some leeway in our argument to address the response, that is fine as well.
Okay. These are pretty much guided by the civil rules. These don't fall under our normal Rule 88, I don't believe. But in any event, we could do one of two things, really. We could address it and then give you some latitude to respond. Alternatively, I could set it over a week, give you an opportunity to file a response if you want.
We're prepared, just if Your Honor can give us some latitude so we don't delay the matter.
Yeah, we can do that.
Okay, it shouldn't be much more, Your Honor, after reviewing the declaration that I would add on.
Okay. So this is your motion. Go ahead.
Okay, thank you, Your Honor. My client is the moving party here. She has filed a petition to terminate the hearing guardianship. This case started out in 2018 as a non-parental and then converted in 2022 to a guardianship, in which a final plan was entered 12/12/22, which included a 4-phase plan for a return home. My client has officially been in the 4-phase plan since Your Honor ordered it April 16th, 2024. I don't want to go into any more of the history. I know Your Honor is quite diligent, but our petition lays out the history. Basically, the conditions that existed at the start of this case, which was non-parent turned to guardianship, no longer exists anymore. And just to highlight kind of the accomplishments that my client has done, in 2021, she did a 30-day inpatient program. And this is really where she said, you know what, I don't want to be like this anymore. I need to turn my life around. I need to be there for my son. And when she was done with that program, she then went into a 13-month program at Mountain Ministries. After that, she went into a 13-month program at Oxford House. At both of these facilities, actually all of her inpatient, outpatient, she's been required to drug test. All of those have been clean. She has been clean and sober since September 28th, 2021. That's including hair and urine tests. It's been, I think it's almost 35 months now, but at the time we drafted the motion, it was 34 months. When she was at Oxford House during during that time period, that's when she got her driver's license reinstated. She went through 9 months of having an interlock, got that removed. At the end of last year, she obtained her commercial driver's license in connection with her employment at U-Haul, which she has been with for about 1.5 years. She has twice been promoted at U-Haul and now is a U-Box driver. Throughout this entire case, she has provided to the court and to the guardian clean tests, UA's hair. She's tested when asked, and every single one has been clean. She went to her first AA 10 years ago. And she still continues to go on Monday nights when she is off working time. She's never once had an issue with obtaining or maintaining a job, except for I think when most parties did during the pandemic time. She has her own vehicle. It's insured. She's paid off all her child support. She's current. She has her own house, which is a 2-bedroom, 1-bath apartment in Kelso. There's only 2 people that live there, herself and her son. He has his own room, his own furnishings. It's all set up. She has done everything the court has asked her to do. Her last hair follicle, which is submitted to the court, was June 14th, 2024. Again, that was negative. Throughout this case, Carmela has consistently given my client more time, which demonstrates have fear or concern any longer, because if she did, why would she give more time? Most recently in July, Carmela gave my client 5 days, 4 overnights, which consisted from Wednesday after school to Sunday at 6. This is, again, a clear indication there is no concern. And this is a transition. She keeps talking about she wants a transition. What more can we do for a transition than 2.5 months of her having primary time? My client has, regarding school, he is currently at Kessler. At some point in time, will go to Wallace. That is not something where she is going to yank him out today and put him in. She is going to work with his teachers at Kessler and decide when it is the best time to transition to a new school, whether it's at break, whether it's at the end of next year. She is going to do what's best for him. She has a large support network, including her ex-boyfriends, and that's what we want to make clear. It is an ex-boyfriend. Parents who have been extremely involved in Gage's life. Her best friend husband, and her friend Q are also part of her network, all clean and sober, and these people are all available at a moment's notice. When Gage is returned, she plans to enroll him in therapy to address any issues he may have with the transition, school, just any concerns. My client also wanted the child to be in therapy, but Carmela would not cooperate in doing so. Both the child and the guardian have seen a complete change in her, and they're simply ready to start their lives. The parties did try, since, Your Honor, after our last hearing, we've had numerous conversations about trying to terminate the guardianship outside of court. And really what it breaks down to when we look at the disagreement is the guardian wanted confirmed court-ordered visitation. And that's where the talks broke down. And when my client says she's more than willing to discuss visitation with her, but she doesn't want it to be court-ordered, because once it terminates, there is no more ordered visitation. And that's where it broke down. She wanted a guarantee. My client doesn't want a guarantee that's court-ordered. She's very grateful for her help, but at this time, it's time for him to return home. He's going to need a transition in her care. He's going to need to realize that Charity's mom, not Carmela. Carmela is not mom anymore. He needs to get into his new routine, therapy, school. He needs to transition home and just kind of decompress. And at that time, once they've gotten a routine, a schedule, he doesn't have all these things thrown at him, then I think it's appropriate to discuss the visitation schedule. Just like any other parent, she has the right to decide who sees her child, when, and where. That's not a court order. And she's definitely willing to talk about it. But the whole goal of this guardianship the entire time was been to transition him home and return him home. My client has met and exceeded that goal. The child's very excited to return home. He doesn't have any anxiety or fears. No longer that person that appeared in your courtroom in 2018. She is now willing and able to do all of her parenting duties, and she's provided that proof to the court. In regards to Ms. Carmela's response, the first 3 paragraphs of her response were things that happened over a year ago and have already been dealt with and brought before the court. The majority of her declaration is spent complaining about my client's then boyfriend. She keeps saying boyfriend. It's not a boyfriend now. It's an ex-boyfriend. They don't live together. They're not together. And it's likely that he is not even going to be outside of prison for a very long time. She was given the whole issue about the address. Again, a few court hearings, we decided that she was allowed to go to the address. The issue of the housing and the landlord, again, the guardian already brought that up. She keeps saying it's Charity's boyfriend did this or that or this or that. She's just trying to deflect the court that Charity's asking for Gage to return home. The guardian isn't wrong the guardian is wrong, I should say, when it states we refused a GAL. At our hearing in April, the court specifically said that the current plans stayed in place. We're moving into phase 4. Nothing's changing absent a GAL. You specifically stated at the hearing that any issues can be brought before you, and at that time we can discuss the GAL. You ruled phase 4, and that was it. We weren't asking for a GAL. So if there was any need for a GAL, if there's any concerns, the court specifically instructed Carmela to bring any issues before the court. She's never once since April 16th, 2024, brought any issues to court, brought any issues to court that would require a GAL or even discuss the issue of a GAL. And really, like I said, it all revolves around she wants guaranteed court-ordered visits, and she can't get over that fact that there isn't going to be once it officially terminates. Even after we filed this petition and served her, she never once reached out to me to discuss any concerns, didn't say, hey, look, why are we doing this now? We need this, this, and this. I said, hey, if you're in agreement, let me know. We can sign outside. She just refused communication. Carmela says that Charity wanted her to agree he move in at the end of summer. That was actually Carmela's idea. He moves in at the end of summer. I want this visitation. It was all based on give me guaranteed visitation. Again, these issues of Gage and his suspensions, again, old issue. Already brought up, already dealt with. And we're talking about the old issues of suspension. If it was current, she would have brought it up after the last hearing. Again, she didn't. She states she wants an actual transition, but they've already been doing that this entire summer. She also states he has recently been suspended, but it fails to provide any proof. She didn't provide anything in her declaration. She didn't provide any text. She didn't provide anything from the school. She was served extra time with this petition. And again, she filed her response over a week late. So she hadn't even do this. She said she provided Charity notice about a meeting at school and she didn't show. Again, there's no proof. There's no text. There's no proof of meetings. There's no response. She said she's asked her to go to IEPs and twice she hasn't come. Again, there's nothing that shows she asked her and Charity couldn't come outside a work issue. She's provided nothing. Regarding her current apartment, Carmela has never once asked me to go and see it. Even after being served with this, Carmela refused conversation. She never once called me. She never once sent me an email and said, I want to go see her current apartment. This is just a delay tactic on Carmela's point, because if she really wanted him to return home and she was really concerned about the apartment, then why didn't she say, I want to go see it? She didn't say anything. Hold on, Charity. She keeps trying to basically say, David this and that. She's just trying to deflect. And she wants it to appear like my client's some kind of drug addicted derelict when that's no longer the case. They're not together. They don't live together anymore. So at our point, we're requesting to terminate the guardianship immediately and order the child to return home. Since we are in the middle of a school week, choosing a time like on Saturday or Sunday would make more sense because it doesn't interrupt Gage's week and they can plan the transition a lot easier versus just saying, hey, you're going to your mom's house today. I think that would be the least disruptive. And Your Honor, we also provided proposed orders for you to sign as well that we have not received any objection to. Thank you.
All right. Give me just a second. Just one comment, and then I'll hear from Ms. Gill. It's a bit of a misstatement to say that no evidence was provided because the declaration is in fact evidence under oath, and that is just as convincing as a document from the school. So yes. That's a complete misstatement of the court rules or the evidence rules. So
I apologize, Your Honor. I meant she didn't provide any evidence from the school. That's I didn't mean her declaration wasn't evidence. Apologies for that misstatement.
All right. So Ms. Gill, I did review your written document. It says it's 5 pages, and I did review all of that. Do you have anything you'd like to respond to?
Yes.
To that?
I'd like to first off say that what Ms. Jocelyn just did is exactly what she did in my last court hearing, where she railroaded over everything. I didn't get to speak. She just pretty much told the judge what to do. It was stated at the end of our last court session, they wanted to modify the plan. And they were told, if you want to modify it, I will grant that, but I want a guardian ad litem. They said, no, never mind. We'll just stick with our regular phase 4 because they didn't want the guardian ad litem. My biggest concern right now is they're claiming this is an ex-boyfriend, and this man just stayed the night again in her apartment with Gage. my biggest concern with him is that on Father's Day, while Gage was in her care, he was arrested for substance, like for drugs, for guns, for having burglary tools. And she is continually bringing Gage around this man. Not just that, but this summer while she had him, she would not tell me who was watching him. And I had to find out from Gage that her ex-boyfriend or whatever he is, his parents took Gage out of the state without my permission, without contacting me at all. They just took him to Eugene, Oregon, and then back. And I only was granted to see her apartment this last Sunday, a few days ago. I have asked all summer if I can pick him up. And every time she'll say, okay, and then change her mind on Sunday saying, it's just easier if I drop him off. I already have to do this. Or she guilts me by saying that she'll just have to keep Gage home all day Sunday and do nothing with him because I want to be the one to pick him up. And I think that's manipulation. My biggest concern of why I want a transition is because for 2 years now, she has only went to his kindergarten graduation. Gage was suspended at least 5 times last year. Not one time did she go to a reentry meeting. Not one time did she go to an IEP meeting about his special education. She never brings up the fact that I've been waiting now 2 years for an autism and ADHD screening that we finally just now are getting, we're going to be seen within a few months. She rules all that out. She doesn't talk about his behaviors or the fact that he needs transitions for everything in life, even in school. They have to have everything set up because he can't handle transitions. So I've been asking her to please come to these things. I asked her to come meet his new teacher. She did not show up. I asked her to come to the suspension meeting so he could go back to school. I didn't even get a text that she wasn't going to show up. I texted her later and said, hey, I thought you were going to be there with me today. And she's like, oh, well, someone called in. I couldn't make it. Stuff like that happens and they would have to reschedule. I go, yeah, but Gage can't go to school until someone's there to have that meeting. He has a lot of anxiety about moving because he's told he cannot go to the same school and he's going to be starting a new school. And it's been put in his head that a new school is going to make all these behaviors he has at school go away.
Your Honor, we're going to object. This wasn't in her
declaration. I didn't interrupt
declaration.
you, ma'am. I didn't interrupt you.
I'm objecting. So,
I
Your
let
Honor,
you
this
speak.
wasn't in her declaration.
It's in the declaration.
Not that he has all this anxiety. No. She said it, but not related to where she's going.
You're
Please
saying
let
a lot
her
of things
go
that
on
weren't in the
further.
declaration.
And I think
This
that
is
we
what
can look.
happened in my
Right.
last court case. She just talks over me every time.
Miss Jocelyn, I'm gonna have you just hold on for a minute.
And the fact that they're claiming it's her vehicle, when she got her blow tube removed, she had wrecked her car and started I have asked for over 6 months to see insurance, and not one time have I been provided any type of insurance on these vehicles. She showed up 3 different times in different vehicles that I don't know whose they are, and I've never been shown insurance. Back when David was full-time living there and driving Gage, I asked for his driver's license. Not one time would she provide it for me. And those are major concerns. She keeps claiming they've provided them to me, and I have no proof of that at all. And I would think that a transition with Gage, so when summer break ended, because we did a summer schedule where, yes, I let her have more time. I told her, I was like, if you want to continue these days, then what I would expect is you're fully responsible on the days of school that he has. So if the school calls and he needs somebody to be there, then I would expect you to be the one to come and support him. And she told me she'd have to send her boyfriend's parents there instead. And right now, Gage needs her. He needs her to step up and be the one. I spent 5 months last year taking my lunch break at his school to help him because of how bad his behaviors were at school. Not one time did she offer to help me with any of that. So it'd just be nice to see her start taking over some of the school stuff before he moves home, because he's never experienced school with her, ever. So I just don't think instantly moving homes after 6 years of his life and then changing schools is appropriate. And I don't think I'm wrong to ask for court appointed visitation rights with him. I've had him 6 out of his 8 years of life. And throughout the course of these years, I have multiple text messages that I could submit where she tells me that I will have nothing to do with Gage when she gets him back. And for being the sole provider for him for 6 years, that will be devastating to him if I'm just yanked out of his life like that. I have no, I'm not against him going home, but I want him to go home the right way and feel supported throughout it and know that she can do school, she can do doctors. Or my biggest thing is I worry is if he moves home before we get to have this evaluation for autism, I think she's just going to dismiss it because she doesn't think he has any of these issues that I have documentations of all these years through his doctor and specialists for.
Okay. Thank you. Ms. Jocelyn, any response?
Yeah, really quick. We've already talked about the transition they've had over the summer. She is primary as of right now. Like I said, I apologize for misstating, yes, declarations are evidence, but all of these things that she's saying she texted my client, she could have easily attached and she didn't. She could have got anything from school saying that he was that he had been suspended. She didn't do that. Even today, she said, oh, when he was living there full time. She acknowledges David doesn't live there. And so I think the problem with the court ordered visitation after termination is there's nothing to support that. And that the problem that's going to be with this ordered visitation is Gage doesn't know who's the authority figure, who's mom. The transition is different than terminating with visitation assigned. I understand if we want like a slight transition, but let's put that plan in, have a date set that he is to return home. My client is the parent in terms of all medical needs, but we can put in the termination paperwork that is guaranteed she will take him to the autism evaluation. That is not an issue. If it's something that he needs, she's going to do it. She has proven everything that she needs to do. She is done. I think you can see clearly these parties don't agree. If you look at the demeanor of the guardian, she is very upset. I get it. She's had the child for a very long time, but my client was told to do 1, 2, 3, 4, 5, and she's done it. It's time for the child to return home.
Okay. Give me just a minute here. I'm going to go back to the
May I say something, Your Honor?
Sure, go ahead.
The concerns that Miss Gill has brought up recently, the only thing I'd like to add to that is my ex, my son, about 8 months ago, asked him to be his father. He's wanted a dad his whole life. So when that relationship ended, it was a very difficult situation to walk around because the child's heart was now involved. And so I have given supervised visits and I've made sure that they were the safest they could be. I've made sure that my ex was doing everything that he needed to do in order to be seen. There's just been a handful of supervised visits. And I made sure that he was clean and sober. I made sure he was checking in where he needed to check in with his probation. And then all of these other concerns about school, I've never been given the opportunity to go to any of his school meetings about him being suspended for school. In fact, she's given me very little information even after he's been suspended. It wasn't until this last one that she invited me to it, but somebody called out from my work and I was the only one there covering the front counter and I couldn't get anybody to come in and cover it. My manager was out of town, so I couldn't do anything about that. And then as far as her concerns about me being able to be the person who takes care of him, like if something happens at school and I go pick him up, I'm a truck driver. So, and I'm only a truck driver right now, 3 days a week. Every parent has an emergency contact for their child for if something happens and they can't be the one to immediately get there. There's tons of parents that live outside or work outside of town. I told Miss Gill that I would only have to use my ex's parents who Gage calls grandma and grandpa. if I was out on a route that wasn't here in town. And they are certified foster parents through Washington State. So they are more than capable of making sure that he's safe and secure. My ex's mom is a nurse. She's been a nurse for over 30 years. And so they're very good, safe people to be there for him. Engage, trusts them, and loves them. So what I told Miss Gill is that sometimes my routes for when I'm driving truck are only an hour long. So, and that happened this last week. Both my routes were only an hour or 2 hours long. So I texted Carmel and I said, hey, I'm available all day today. So if anything happens at school, I'm available. I told her that in the off chance that I was out at the coast, which is a 2-hour drive back, if I got called, and then I would have to call somebody else to be able to go get him, which would be the trusted contacts. I also asked Miss Gill, what I told her ideally that I wanted was when Gage came home, I still wanted her to be a support person for him. So we could work together. And if I was out on a route, I could maybe call her and say, hey, I'm this far away. I can't get back until this time. Would you want to be the one to pick him up until I can get there? She told me that she didn't want that because that was me trying to not be the responsible parent, that I was trying to push my responsibilities off on her when I was really just trying to keep her included in the support network for him for when he does come home. So all of these things that she's saying, I have evidence to prove otherwise. She didn't include any of those things in her response, so I wasn't prepared to argue that point. But I have over 1.5 years of messages of me telling her that I don't want to cut her out of my son's life. That would be devastating to him. But what I wanted is that for me and her to be able to work together to set up these visits. I do believe that when he comes home, he needs to adjust here first before we have set visits, because we have to learn what my new work schedule is going to be, because my work schedule will change once he comes home. And we have to learn, I have to get in the motion of getting him up, taking him to school, getting him from school, all of that. So in order to adjust for that, that's going to take some time for me and him. And then after that, we can set up visits. And I've never been opposed to allowing visits or phone calls during any of that if we can figure out the time to do it and appropriately. So I've been doing this for 6 years. I've done everything I possibly can to overcome the obstacles that started this case. I've done more than what was ever asked of me to do. And I just believe that it's time for him to come home. And I would like to be given the opportunity and the freedom to be his mother and to raise my son.
All right. So in looking at the statute, and I've commented this before, it's a very poorly written statute and doesn't provide a significant guidance for the court or the parties. And in looking at the 2611 13240, which talks about what termination of guardianship is based upon, the original basis to create a guardianship under 11-130-185 is clear and convincing evidence that no parent of the minor is willing or able to exercise parenting functions is defined under RCW 2609-004. That would have been the basis when this case was started. So we're now at the point where under the termination, I have to find that the basis of that no longer exists unless termination of the guardianship be harmful to the minor and the minor's interest in continuation of the guardianship outweighs the interest of any parent of the minor in restoration of the parent's right to make decisions for the minor. What it is clear in this case is we've got a young child who has spent this vast majority of his life out of the mother's care. Mother's made significant progress in addressing the issues that led to the original third-party custody and ultimately into this once the law changed. What's interesting is that the legislature defined what the standard of proof was in establishing a guardianship. They didn't say anything about what that would be to go the other direction. One would assume that it'd be the same standard, but that may not be the case. That may be somewhere else in the statute that I haven't run across. I think given in this case, we've got 80% of this young man's life has been in a protective placement under the court order. And I think that looks like when Commissioner Nelson set up the original guardianship and set out the 4 stages, and I believe I was the one who said we're moving to stage 4. What I guess where I'm at this juncture, there are concerns that are there, and I don't like to make decisions based purely on concerns, because I don't think that's good practice for anybody. But again, and I'd be happy to entertain briefing on the standard of proof to undo one of these things that's not clear from the statute. But it would seem to me that the same standard applies both directions. But that, again, I don't know that that's accurate. What I'm inclined to do today is to appoint either a court investigator or a guardian ad litem to take a look at this. This is one of those cases where it very well may be, we may be at the end of the guardianship. And if that's the case, then he would need to transition home. The nature of Washington law is that this court would not have any ability to enter an order of ongoing visits under this statute. There's a different statute, which third-party visitation statute, which very well may apply given the circumstances in the case, but that case isn't filed and isn't before me. So what my thought today is to appoint a guardian ad litem to take a look at this, verify kind of where we're at, and Ms. Jocelyn, I would be interested in some sort of legal briefing on the standard of proof on the unraveling or undoing of one of these. And it's unclear to me between RCW 11-130-185, which sets a standard of proof, and 11-132-45, which is silent as to a standard of proof. So I certainly would listen to some, if there's some law there may be some case law out there I haven't seen.
Yeah, and Your Honor, when I look at this, I look at 11-132-40, which says when the court finds the basis under, and I think you just said this, 11-130-185, it seems very not as detailed as you said. If it finds the appointment is in the best interests, or that it's clear and convincing that a parent is not willing or able to execute the parenting duties, which I think we've shown. We're happy to do a court investigator, but I think, Your Honor, we can avoid all of that because the guardian isn't saying don't terminate. The guardian's saying she wants a transition and she's happy to terminate. So I don't think that we need to necessarily go into the investigation or briefing because she's in agreement. I think what we, of course, with Your Honor's agreement, we need to see like what is it that she feels is a good transition. And if that's agreeable by my client, I think we can avoid the court investigator route.
I would like to have an investigator. I don't want to agree to anything with Miss Jocelyn outside of court anymore because she has continued to bully me. And
okay,
I'm going to object to this. With her.
Oh,
we're asking to do this on the record. That's an order. And so you can see the problem we're dealing with. She says one thing and then she immediately takes it back. In her paperwork,
well,
she said she
let me stop you. I am of the opinion I need a guardian ad litem or an investigator. And I can do either one. We have our court investigator,
Ms. Schaefer.
Ms. Schaefer, who would probably be a little able to address this more quickly. I believe that I need to double check on that.
We're in agreement with an investigator. I think Ms. Schaefer does excellent and thorough job.
Yeah, I think given the way that I mean, it's an unusual circumstance. It doesn't really fit into the standard JL kind of thing. So I'll appoint Miss Jocelyn to look into this.
Ms. Schaefer?
Not Miss Jocelyn, Miss Schaefer, I'm sorry.
No, that's okay.
Miss Schaefer, and get me a report back. I'll need to check with her what her timeline is. We're probably looking at least a few weeks, only because she's going to need to talk to both parties, probably look at a few records and review the court file. So I think I'll do that appointment order off docket once we're done with this proceeding. And I guess what I'm thinking about would be just setting a review date. I'm out the first 2 weeks of October, so if we set a review on the 15th, which is 4 weeks from today, that's probably sufficient time for her to get us something, or at least tell us if she needs more time.
Perfect. 15th at 10 a.m., Your Honor.
15th at 10 a.m. And like I said, I'll get the order appointing done. And then we'll just review this. And I'm not denying the motion. I'm simply going to table the motion. If you want to file anything in addition to anything in writing, you're certainly welcome to do that. But at this juncture, probably I'll be looking to see what Ms. Schaefer has to say.
Not a problem. So are we just sort of tracking this along with the review?
Yeah, when is our next review?
We don't have, there's no review set in this case. So
Okay.
I'm figuring if we track it to 10:15, and I imagine if Ms. Schaefer needs more time, we can communicate with your JA to arrange another date.
Okay. That'll probably be sufficient, and she can at least tell us at that juncture where she's at and what else she needs, if anything. And I don't know what her recommendation very well may be. But I would, Ms. Jocelyn, if you've got, this would probably be interesting for all of us as to what, how does the 185 and 240 interact with each other in the standard approved to undo a minor guardianship? It's an interesting question.
It is.
So, all right. So I'll do that order. We'll be back on the 15th of October at 10 a.m. And hopefully Ms. Schaefer will have something for us or tell us what else she needs.
Thank you, Your Honor. Appreciate your time.
All right. And we'll maintain the current status quo with visitation as is.
Okay. Thank you.
Okay. All right. And that brings us to the Johnston and Gill matter, 2245 or 45408.
Good morning, Your Honor.
Good morning. So I have received both an original and an amended report from our investigator. I did not see there was, I think I'd requested some briefing on the termination of these, and I don't think I saw anything on that.
I apologize, Your Honor. I thought we were going to do that depending on what Ms. Schaefer came out with, and for the 99% of it, we're in agreement with Ms. Schaefer, so I wasn't sure that we needed briefing, but happy to go over what our position would be based on 13240.
Okay. And Ms. Gill, are you here?
Yes, I'm here.
All right, there we are. I didn't see on my screen, sorry. And you've had a chance to look at the report from Ms. Schaefer as well?
I have, but I'm not in agreement to it.
Okay. Where have you talked at all with Ms. Jocelyn?
She has
No,
not.
she hasn't spoke to me in quite a few weeks.
It's the other way around. She hasn't reached out and asked to talk. And last time I got an email from my client, she didn't want to talk to me. So we haven't gotten any objections to the report. We haven't gotten any written objections. We do have Ms. Schaefer present. So I know Your Honor wanted to hear from her. I think that's the most non-biased person here in the matter.
Yeah, and I've reviewed both reports. Ms. Schaefer, did you have anything you wanted to add over and above what's in your reports at this point?
Not at this time, Your Honor. I know both parties reached out to me for a little bit of clarification, but I will wait until you make your final ruling. And then if I need to clarify on a few things, I will.
Okay. All right. So again, if everybody's read the report, I mean, I understand what the recommendation as far as this goes. My real question, and this is more of a legal question than anything else, is we have an order that created this, and then we're now at a point where we're trying to, or at least there's a request to undo the guardianship.
Mhm.
And so from a process standpoint, it's not clear, and the statute doesn't seem to provide any process. So I guess I'd like to hear from the parties as to what your thoughts are about that.
Yes, Your Honor. First, we want to commend Ms. Schaefer did a very in-depth review of this matter, and I think was really working to do what was best for Gage. My client's in agreement with it. The only difference is that Ms. Schaefer is recommending visits for 6 months. My client thought it was 3. My client's fine with every other weekend for 3 months. After that, she wants Miss Gill to remain in his life. They can work together. They're going to need to work together. And if they can't, then Miss Gill's, what she could do then is she petitions the court for non-parent custody, but it wouldn't be under the guardianship. It would be under the non-parent custody. It'd be a different petition. And so my client's position is that based on RCW 11-130-240, the court is going to terminate it when the basis doesn't exist anymore. And then if we look to subsection 6, subsection 6 states, when terminating a guardianship for a minor under this section, the court may issue an order providing for transitional arrangements that will assist the minor with the transition of custody and is in the best interest of the minor. So I certainly think that having that transition of 3 months, or she had said 6 months, my client would like to do 3 months, it's whatever the court orders, would be a good transition. But based on everything that Ms. Schaefer has said, she doesn't want to and I apologize, Ms. Schaefer, if I'm misstating, but I'm glad you're here. She doesn't want to prolong based on Gage's, he doesn't do well with transition. So what she would like is for 2 weeks from the court order for Gage to switch his schools and would go back to mom that Friday before. And so she just wants to do the transition in a sense all at once. But I think what Your Honor what I would think is what she has put forth for visitation is a transition period. And so whether it's 3 months, 4 months, 6 months, we have a transition, but it has to end at some point. Otherwise, the very definition of transition is a change or shift from one to another. And so the guardianship has to terminate at some point. 3-month transition seems fine. If the parties can't agree, that gives Ms. Gill a 3-month lead time to file a petition for visitation if she feels that they're not going to be able to agree. So I think that Ms. Schaefer had set out very well the transition in terms of making sure my client has any before and after school care. My client set up with Columbia Wellness for therapy. The therapist can actually come out to Gage's new school, so there won't be any kind of interruption. I think she said they can come out up to twice a week for him. And so I think what Ms. Schaefer has laid out for a transition is a good plan, and that would be the plan that we would want to adopt.
Yes.
Okay.
And I believe the only thing that's different in the 2 plans was acknowledging that my client had every other weekend had every weekend when it said every other weekend. And I think there was a spelling name, a name that was spelled incorrectly.
Yes.
There was some other things I wanted to address in the report that were incorrect, though, which would be Gage with his struggling with school. Her report stated I've only been called 5 times since school started. I've been called 19 times since August 28th to help de-escalate Gage in a meltdown at school. I've been called 5 times to respond and come to the school and leave work. He's been suspended 3 times since August 28th. And that's not even counting the times he's just asked to call me just because to help check in for his day. My big concern is I understand her saying a slower transition would be him doing one transition after another. But my fear is flopping his whole life upside down to change schools and to move all at once is a huge change when Charity has not taken over any parental roles. She's not done any of the schooling. She's only came to one meeting in over 2 years. I offered her, she told me this weekend he has a chip in one of his metal cap teeth. So I said, okay, I'll call and I'll schedule an appointment. How about you can take him since you need to start taking over these things? And she said, well, then it has to be on either Monday or Wednesday only. And I said, well, it's going to be an emergency appointment. I'm not going to have all the pickings of what will work best for this. It's not scheduling a normal one. And like my other concern is she's complaining about how she doesn't know how she's going to come up with $600 for daycare for him. But all these things have to be in place with just a few weeks' notice.
I object to that, Your Honor.
And nowhere in any of her declarations does she talk at all about me or our family being there to support Gage. She only talks about her boyfriend's family being there to support him.
I object to that point as well, Your Honor.
Yeah, it's actually misstates what she said. My client was stating who her support is in terms of who can help her. She, of course, has reached out to Carmela since and wants her to help her, but these two have been arguing the vast majority of the time, including nasty messages Miss Gill has sent to my client after. And so it's not, she's telling you who is guaranteed to be her support. It's not acknowledging Carmela.
Okay. I didn't interrupt you guys.
Okay, well, everybody hold on a second. This goes back to the issue of the legal basis for terminating, which it potentially requires some sort of hearing as to whether or not the original guardianship, the reasons for that have been addressed.
And that's what we set this hearing for, Your Honor. We set the hearing to determine based on that. We indicated, everything that was set forth in 130-185 no longer exists. There hasn't been anything presented to the contrary that shows that it hasn't existed. We've now since had Ms. Schaefer investigate, who does a far more thorough investigation than either myself and or Ms. Gill does into the matter. She is non-biased and said, my client has this, this, and this. She recommended my client do certain things, and she did that. So that is based on, we can terminate. You terminate when the basis no longer exists.
I'm looking for the evidence as to the basis why we created this in the first place and whether those have been addressed or not. And that's what I'm looking for right now.
Oh, apologies, Your Honor. It's going to likely be in the prior case number. The case was originally started as a non-parent custody matter, and then my client moved to convert it to guardianship. So it's under the first case number.
Okay, I don't have that in front of me. So what I think I'm going to probably need to do is get this on for a trial assignment. We'll set it for a hearing.
Okay.
So, and I don't know, for my clerk, can this go on to tomorrow's trial assignment, Doctor? Is that too late? Does it need to be on for next week?
Your Honor, this week has been finalized already.
So it'd be on for the
next week.
23rd?
Yes.
Okay. So what I'll do then, I'm going to set this on for assignment for a hearing time so we can get all of the information before the court and have a hearing on it.
Is there any way, Your Honor, we could do 2 weeks out so I can give court or my work notice? Next week, we're like extremely short-staffed.
All that'll be happening is setting a court date.
Okay.
We won't be having a hearing on the 22nd. It's essentially a hearing at 9 o'clock to set a court date.
Okay.
And Your Honor.
Yes.
So some of the things that the court investigator wanted me to do, like getting a daycare set up and getting those things all set in place. I'm struggling to be able to finalize all of it because I don't have all of the information that I need. I don't have his immunization records. I don't have his doctor's information. Like, I've only even been invited to 2 different meetings when it involves my son. And the investigator has that information as well. I was able to show up for one. I was short-staffed at work, and the person that was coming to relieve me didn't come. So all these things that I'm trying to get set up, I'm kind of hitting a roadblock with, because until there's an order where he can, come home to me, I can't get anything established until there's paperwork showing that I have the legal rights to do that. So I went and talked to the daycare yesterday, and they're holding a spot for my son, for that to be set up, but I have to get like his medical information, and I don't know how to go about that, because every time I try and contact Miss Gill about it, it becomes a fight.
Well, once we have an order to that effect, then that would probably be the time that moves forward.
Okay.
I don't have an ability to do much else with that right now. So I'll set it on for the 23rd at 9 o'clock for setting of a trial in the matter, and then we'll go from there.
23rd at 9 a.m., Your Honor.
23rd at 9 a.m. That's a Zoom hearing. And then
Thank you.
for my clerk, if we could make a note that for that trial, we need to have both case files on for that. I don't have the other number in front of me, I don't think. But we're really going to need to have both pieces.
The non-parent custody, Your Honor.
Correct.
Okay.
All right. And in the meantime, I'm going to leave the status quo, and then Ms. Schaefer, there's probably nothing else you need to do at this juncture. And so
Can I just put on the record one thing, though, because I know it was in question about the length of time that I suggested that Ms. Gill have every other weekend. And that was simply because Ms. Gill was a great advocate for Gage at school. And so by the time that this gets set up, that would give Ms. Gill pretty much the remainder of the school year to help her sister advocate if that relationship could be repaired. I did want Ms. Gill to feel like she still could support Gage in that way. And by seeing him every other weekend, she could check in with him. That was my reasoning for the 6 months.
Okay.
For transition time.
Okay, very good. Well, your report will be part of whatever disposition is ultimately ordered, and that it does cover all the points that were requested. So thank you.
You're welcome.
And Your Honor, I have the non-parent custody number if you'd like it for your records for ease.
That'd be great. Thank you. Go ahead.
18-3-00500-08.
Thank you.
No problem.
So if we can make sure both of those cases are tied together for when the hearing is set. Okay.
Thank you.
Thank you, Your Honor.
You're welcome.
Thank you.
I believe that's everything on this docket. So we will adjourn.